Great. Thank you, everyone, so much for joining us today. We are here with the National Association of Manufacturers Legal Center, as well as the Manufacturing Institute, and our partners with Fisher Phillips. So, before we get this discussion started, we would love to review a few housekeeping items with you. First, everyone, as you're joining us, you will be muted upon entry, so you can sit back and enjoy the discussion. You can have the best view of today's presentation by enabling the speaker feature, which is in your top right-hand corner. And we have the chat feature open, so if you have any questions, any additional resources you would like to add to there, we'd love to have it. And we will have a Q&A portion at the end, and we'll be happy to take questions as time allows. But without further ado, I'd like to get us started. I will love to introduce you to my colleague, the President and Executive Director of the Manufacturing Institute, Ms. Carolyn Lee.
Thank you so much, Marisa, and thank you everybody for joining us here this afternoon. We're glad to be able to host this conversation with all of you because this has been very much a hot topic in the last several weeks. And so I'm glad to have a chance to join and be joined by our partners at the National Association of Manufacturers Legal Center and to present this information to you and to further this conversation. The Manufacturing Institute has been on a journey to be able to dig into DE&I activities and lead manufacturers to being able to implement these programs and activities since the beginning part of 2020. And so this is another in our long series of content. You can find more resources at the Manufacturing Institute's website under the DE&I link and the resources tab. So with that, I'd like to introduce my colleague, the Chief Legal Officer of the National Association of Manufacturers, Linda Kelly.
Thanks, Carolyn, and let me join Carolyn in welcoming everybody today. One of the functions that I serve in my role as the Chief Legal Officer here at the NAM is to ensure that our manufacturers are getting access to the information they need to meet their compliance obligations when there are major developments in the law, as there has been recently in the affirmative action cases. And so we're really, really pleased to have our law firm partners at Fisher Phillips here today to lend their expertise to help us all understand better what the implications are of these Supreme Court decisions on DE&I programs for employers. So without further ado, I'd like to introduce our speakers, our experts today. We have with us Sheila Willis. She is a partner with Fisher Phillips Columbia, South Carolina office and is co-chair of the firm's Affirmative Action and Federal Contracts Compliance Group. What a great background for all of the questions I'm sure you have today. She helps companies of all sizes as they navigate a variety of employment issues, including federal contracts compliance issues. She also has the interesting side job of advising some higher education institution clients on Title IX compliance and other issues. Joining Sheila today is Colin Calvert. He's a partner based in Irvine, California, and he's co-chair of the firm's manufacturing group. Colin's practice focuses broadly on employment law and touches every aspect of the employment relationships. So we are looking forward to hearing from you two today, and let me turn it over to you.
Thank you so much, Linda. Sheila and I really appreciate the opportunity to speak with the membership today and want to express our gratitude to the association and the Manufacturing Institute, for having us, particularly on this issue, which is something that we have been grappling with our clients over the course of the past few months, something that is emerging, something that, quite frankly, we don't know exactly what it is going to look like down the line. And it's one of the reasons I'm so grateful to have my partner Sheila with me today, because she is, in my opinion, singularly positioned to talk on this issue and brings just a ton of experience and expertise on it. Outside of just the manufacturing area, this is something that she knows coming and going. So I'm thrilled to have her. I'm thrilled to be with you guys today. And just want to touch on two key points. The first is we have the chat open. I encourage you guys to use the chat to toss your questions in there, and we will do our best to answer them as we move forward today. I know that inevitably we won't touch on everything, but I typically do my best to answer every question along the way. So if there's anything left over, we will get back in touch with you. We'll do what we can. We'll make that commitment. But, and Sheila, you might want to push to that next slide now. One of the issues that we're going to have to talk about today, and it's going to come up time and again, is that we are in an incredibly emergent area here, right? The case we're going to talk about is not an employment case. That's our bread and butter. That's what we normally deal with. Today's case and the impact and everything else we're discussing sort of is outside of that employment relationship, but so closely parallels things that are important to our clients, to employers broadly, really critical to the manufacturing industry specifically, that what Sheila and I are going to be doing today is a little bit of future casting. We're going to do our best to look at these cases, look at some of the developments outside of the case law, see where things are heading to give you guys the best guidance toward compliance, knowing full well that what we tell you today might be different in 6 months, might be different in 6 weeks, depending on what bills make it out of different state legislatures, depending on what cases, what appeals cases happens. There's all sorts of different moving pieces here. So we are going to do our best to give you the best guidance as we sit here today, knowing that come October, November, that guidance might be a little bit different. In the interest of time and making sure that we have time to get to as many questions as possible on the back end, I'm going to hand it over to Sheila, who's going to talk about the reason that we're here today, what brought us here, this emerging case, and what it might mean.
Thank you, Colin, and good afternoon or morning or evening, wherever you might be. As Colin said, my name is Sheila Willis, and I'm super excited to be here with you all today to talk about this very important case and the potential ramifications that we're seeing in the employment arena, even though it is a higher education case. Now, to set the table a little bit and give you a little bit of background about these cases, I think how we got to this point is pretty fascinating, and I hope you will too. If you want to nerd out with me, that's fine. If not, I completely get it. That's okay too. So the affirmative action cases in the higher education space have been going on since the 70s, and it really started with this concept and this thought that there would be set-asides within a particular college program for a particular demographic. We are going to have this many seats available for Hispanic applicants, for Black individuals, for women. And that is a lot of the thought of when we hear affirmative action, that concept and this thought of we are going to place people just because they have a particular demographic, whether the thought is that is what it is in the employment context or in the higher education space. But really, affirmative action has really evolved past these concepts of we are just placing people in a particular position. We'll talk about this in employment. We're not making any decisions based on someone's status in a protected category. So that's not the case. And really in the higher education space, these cases have really turned on this concept of race-conscious admissions and looking at whether the college or university, if they are going to consider race as part of a holistic set of factors in admissions, do they have a compelling interest that they are trying to have in their college population and looking at these individuals? So that's just a little bit of background about how we got there in terms of the case line. Another thing that's really interesting about these cases is they have been kind of the baby of an architect of a gentleman named Edward Bloom. Now, Mr. Bloom is an individual who has really made it his mission to focus on the civil rights laws of this country. Mr. Bloom started as an individual who wanted to run in a local election in Texas. And as he was campaigning for this election, he realized that he was in a majority-minority district. And he unfortunately did not win that campaign and has said that his not winning that campaign was related to gerrymandering and decisions that were based on race. And so he has made it a bit of his mission to attack and touch on those types of policies, laws, that sort of thing that impact race. So in fact, a nonprofit organization that he created and spun off has been responsible for a lot of the cases, both locally in Texas and nationally, that impact voter rights. He, in fact, was one of the individuals behind the Shelby v. Holder case, which is a United States Supreme Court case that really changed a key section of the Voting Rights Act of 1964. And so how we get to this case is Mr. Bloom also had a nonprofit organization that challenged the University of Texas's college admissions process that was based on race. There were 2 companion cases about this, the Fisher cases. And during the oral arguments of those cases, there was a comment made by one of the justices that essentially was like, I wonder how this would impact Asian individuals. How does this impact Asian students? And so that comment and that question is said to be one of the foundational reasons that we end up with students for Fair Admissions, which is the nonprofit that Mr. Bloom started for these particular cases, and in fact wanted to recruit individuals specifically of Asian descent to kind of challenge this case or challenge this process. Another unique aspect about this case is at the underlying level, there was not really any evidence of actual individuals impacted by the admissions decisions by Harvard and UNC. And so that is a unique aspect in lawsuits that kind of makes this case unique. This is not typically, you usually can point to someone who has an articulable harm. That is not the case here. But in any event, so we get to students for fair admissions, and that those 2 cases challenged both the admissions processes at Harvard and UNC. The question in the Harvard case was the race-conscious admissions policy unlawfully discriminating against Asian American applicants. And in the UNC versus Chapel Hill case, whether the admissions policy violates the law by giving preference to underrepresented minority applicants without first exhausting race-neutral alternatives for achieving a diverse student body. And that piece there, this concept of first exhausting race-neutral alternatives, that is coming out of the prior affirmative action cases where the courts were saying if you are going to have a compelling interest in having a diverse student body, you really do want to have exhausted all your other efforts before you start considering race in that regard. And as we all know, the court said that the particular programs of Harvard and UNC violated the Equal Protection Clause of the United States. Also held that Title VI kind of has the same standard, and Title VI says that entities that are receiving federal funds cannot discriminate based on race. And so SCOTUS talked about 3 different parts or problems with the admissions processes here. First, they said it wasn't a measurable program, that the decision and the programs were not sufficient for judicial review. This was an interesting concept because this was, and I think it translates really well into the employment arena. This was where both UNC and Harvard kind of talked about the importance of having a diverse student body and why that was important to them, how it led to more livelier conversations in the classroom. It made the students really well prepared to work in a diverse work environment. It really helped build new leaders, right? The court said that is really admirable, but that's not something that's measurable. We can't ever actually tell if you're doing that, or at least there's no evidence in the record that you're actually doing that. And so when I read those aspects of the programs and the beliefs that UNC and Harvard had for putting forth their diversity programs, they read a lot like some corporate DE&I policies. Like, why do we have diversity, equity, inclusion there? So I think as we talk more about this, seeing that crosswalk there is really interesting. Secondly, the court said, of course, that this is going to violate the Equal Protection Clause. And it said that race cannot be used as a negative and universities cannot stereotype, that there's a benefit of race that is an expense of other applicants when you're looking at this. And essentially the court said, when you decide that someone has a value because they have a particular demographic, they are of a particular demographic, I am a woman or I am an African American, when you make that decision, you are stereotyping that person as a representation of every type of demographic or every person that might fit in that demographic, regardless of knowing whether that fits within quote unquote the stereotype that you're looking for. And so that is going to violate the Equal Protection Clause. And it seems like very inappropriate stereotyping. The last reason the court said that the particular policies of Harvard and UNC were something that were of a concern was because they didn't have an endpoint. There was no way for the colleges to articulate that they were going to end this at a certain point. How are they going to determine that they actually had a sufficiently diverse student body? And this was also an interesting point because in another case called Grutter, that was before the Fisher cases, approximately 25 years ago, and I'll tell you why I know that that's the time frame other than math, is because during one of the decision points in Grutter, in that decision, there was a comment made by one of the justices that, well, in 25 years, we probably weren't going to need these types of policies. Race-conscious admissions are not going to be needed. And so that was another point where people were looking to see, well, we're not quite at the 25 years yet. I believe at this point we were at year 2022, and now we're at year 23 or whatnot. But they said there was no rational endpoint, and the colleges and universities really couldn't articulate a particular endpoint to their decision to use race as a particular factor in terms of a holistic approach. So what did the opinion not say? What do we have some, some things that are clear that I kind of want to clear up, and Colin and I want to make sure we're clear on, right? The court did not say that the diversity could never be a particular justification for considering race arguments. They just said that the particular policy of Harvard and UNC, and the way they articulated and the way they put that forth, was not sufficient for them. The other thing that they said that has been really interesting, and a lot of people have been kind of keying in and focusing on, was that the court said there is nothing that stops a college or university for considering race in a context where it mentions how the applicant's life may have been impacted through discrimination, inspiration, or otherwise. And I think a lot of where that came from was part of the oral arguments. One of the things that was raised by Justice Ketanji Brown was asking, if you have one applicant that is going to write in a student essay and they say something to the effect of, my family is really important to me. I can trace my heritage all the way back to the Revolutionary War, and seeing, all of that level of family involvement has really strengthened me, and that's where I get some of my values, those types of things. If you have another candidate that wants to talk about the enduring legacy of their particular family, and it talks about going through the civil rights movement, maybe sharecroppers, going through slavery, how are you going to make that distinction and that decision? Does one student's ability to talk about one particular aspect outweigh another's because one implicitly or explicitly brings about race? So we have this distinction at the very end of the decision that talks about, there's nothing that says you can't look at race in terms of how that has, again, impacted the person, been an inspiration, been a discrimination, that is still something that's permissible there. And one of the things that the dissent said when we're talking about this is Justice Sotomayor really talked about the impact of the decision. And one of the things she said is, today's decision further entrenches racial inequality by making these pipelines to leadership roles less diverse. Admissions to college is therefore often the entry ticket to top jobs and workplaces where important decisions are made. And so that is kind of, we get to a bridge, and I'm going to turn it over to Colin as we talk about those aspects that are kind of immediately there when we talk about this kind of diversity pipeline and this diverse candidate approach.
Yeah, absolutely. And one of the points I wanted to hit on, Sheila, that I think is really critical if we're just looking at an absolute takeaway from these cases, is we need to remember these two claims, these two SCOTUS cases were brought by non-applicants. They were not brought by students. They were not brought by somebody who was able to demonstrate harm. They were really brought by an advocacy group. And it's one of the things that I find most troubling about the decision when I think about how it's going to port over to employers is this idea that we won't necessarily have to have an applicant or an employee who was affected by these policies. We could have an association who, like Mr. Bloom, who we're going to hear more about along the way here, who has made it their mission to fight a fight and will issue X number of lawsuits against X number of employers simply to advocate for their position without having that actual harm. And so I think that's one point of risk. But when we look at how this decision might impact manufacturers, I think the important place to start, which is similar to where colleges started, which is what is our landscape and what are our policies designed to do? What are we facing? And the information I have here up on the slide is actually from a 2021 Deloitte survey that was commissioned by the Manufacturing Institute, done in concert with them. And we see the numbers, and we see that the numbers are fairly staggering, that we're looking at upwards of over 2 million unfilled jobs in manufacturing by 2030. I went to look at the statistics as of last year, and the Bureau of Labor Statistics will tell you that as of last month, there were 567 open positions in manufacturing classified employers, up against only 446,000 hires. And that's been roughly the percentage for the past 6 months. So every month that passes, there are at least 100,000 unfilled jobs. And those unfilled jobs have a huge impact on the industry writ large. And so, Sheila, if you want to advance to that next slide, we'll see that even though earnings are up, right, across the board, at every level earnings are up, we're still not filling positions. And as a function of not filling those positions, we are losing market share, we're losing profitability, we're losing the ability to fill customer requests, to expand, to develop in meaningful ways, to sort of future-proof the industry, because we can't fill these positions. And a lot of what we're going to talk about today, the DE&I policies that many of you have in place, or if you don't have them in place, that are considerations in your workplace and that are essential to filling these roles and meeting all of these areas that currently aren't being met, all of this opportunity cost, a lot of that is thrown up in the air by these college admission cases. And I think that foundation is really critical. And I want you to know it's something we fully understand and appreciate. These policies aren't necessarily existing solely for benevolent reasons. They're obviously, designed to create a workplace that is both in compliance and as functional a workplace as possible, and a workplace that is as open and fair as possible. But they're also essential to the continued success of the manufacturing industry writ large. And that's sort of the background that we're up against. If we look at what some of these colleges have done already to adjust to the court ruling, I think it provides some really strong insight into what employers can do right off the bat to try and avoid any of this parallel reasoning being raised with respect to their practices. So this is a recent article out of the New York Times where they were looking at different universities and what they're doing after these SCOTUS decisions. And I think the really helpful piece in here is down under what UVA and Duke are doing with respect to applications. Knowing that these sort of affirmative action, that traditional system that they had in place is likely not going to pass muster for the reasons Sheila laid out, open-ended, hard to quantify, hard to fully articulate what the value is. They've been focusing pretty heavily on pipeline issues, right? Making sure that they are targeting their outreach efforts to historically underrepresented areas in their universities. That's having the impact of potentially on a DE&I basis, increasing diversity in their workplace, but not necessarily with the same target of race, gender, sex, or any of those protected categories we saw. They're looking to areas where they have not been recruiting students and seeing what they can do to improve recruitment in those areas. That's one initial step that can be taken, right? And we've talked about this with employers across the United States, across industries. One of the things you always want to be mindful of is if you are only looking to recruit in certain areas or using certain recruitment tools, we only post on Indeed.com, you are necessarily closing the door to a broader pool of applicants who might not visit that website or who might not be in that space. Another thing that we've done outside of targeting regions is we've seen from Duke, they're offering actual tuition grants to students on an economic basis. And naturally, we know from looking at any number of other statistics that economically, the country is stratified based on race. And this might have the end game of creating a more diverse.
I don't know if this is me
Oh
or.
yeah, go ahead, Sheila.
Oh, no. It your audio went out for a second and I wasn't sure if it was me or not.
Oh no, it's part of the joy of Zoom, right?
Yeah.
But what we've seen from Duke is they are trying to solve for the problem that was raised by the Supreme Court by targeting it a different way, looking at something that has a statistical correlation in the country, income, and using that correlation to maybe drive DE&I efforts in another direction. Of course, we're going to talk about a lot of the value here and a lot of the steps that are being taken. It's important to note that it's not a one-way street right now. If we move on to that next slide, Sheila, we'll see that universities are facing pressure in the opposite direction as well. We have the Supreme Court taking certain actions. Now the Department of Education, under the current administration, has actually conducted, or I should say initiated, an investigation at Harvard University with respect to their legacy admissions program and the extent to which their legacy admission program has had the opposite impact of precluding diverse candidates from joining the school and being enrolled as students. So the pressure that's in place for employers really does cut in both directions, trying to walk that very fine line, knowing it's incredibly difficult. We have case law, we have some local and some legislative efforts that are pushing in one direction, but of course there's pressure the other way, both because of the laws that are in place, the protections that already exist in the workplace, and the same sort of administrative movements that we've seen. So incredibly difficult area, incredibly fraught landscape, and unfortunately one that we have to try to thread the needle on to come up with the best solution as it stands right now.
Thanks, Colin. And I think another thing that, as we're talking about like this pipeline process and this pipeline thought, even before the decision, one of the things that if you were putting together a DEI program or looking at increasing the diversity, one of the things that you as an employer may have been doing was thinking about expanding where you're recruiting from, exactly like Colin was talking about. We're going to expand where we're recruiting because you are going to necessarily, if you're only recruiting from one institution or one or two or maybe five or however many, you're going to necessarily take on the diverse aspects of that institution's particular student body. The same is going to be true now, and the impact of this decision is going to be really interesting. I think anecdotally, the thought is, of course, this is going to lead to less diverse populations of students in colleges and universities, which is then going to lead to less diverse applicant pools of those individuals if we're recruiting from this area. And one thing that commentators have noted, if you look at California, for example, California has had a state law in place for several years that did away with affirmative action or race conscious admissions for colleges and universities in California. And when you look at the representation of diverse students in California's colleges and universities, both before and after this law was enacted. Again, this law has been enacted, I said, for a few years. Let me be clear, it's probably like 30. When you look at that, the number or the representation of diverse students in the student body has still not reached the level that they had prior to this law being enacted 30 years later. So there is some strong anecdotal evidence that some colleges and universities, if they are not changing their recruiting methods, they are going to have less diverse student populations. And then that is going to have a trickle pipeline effect to employers who are recruiting from these particular higher education institutions, and what that may look like for their diverse pipeline and what that may look like for your diverse talent. And we'll talk a little bit about towards the end of the presentation about some things to be thoughtful about doing that. But in that vein, and we're looking to kind of the education space here because of the, this is where the case, this is the genesis of the case, the genesis of this thought, and we're looking at how colleges and universities are grappling with this decision and making their changes. So Colin and I thought it would be really helpful to talk about a few differences and changes and things that are coming out of this decision. So earlier this month, the Department of Education issued a Dear Colleague. This is how they issue a lot of guidance in the Department of Education. They issued this Dear Colleague letter along with some questions and answers for colleges and universities on how to handle and go forward after the SCOTUS decisions, with the idea that they still wanted to have diverse student populations and some ideas and thoughts for those entities. They said that, for colleges and universities to really focus on recruitment, retention, and inclusion on campus. Not only are we recruiting in different areas, but we're also making sure that once we get folks in the door, that we are retaining them and that we are having a very inclusive campus. What does that sound like? Doesn't that sound very similar to what our inclusion efforts are in our workplace? So the Department of Education recognizing that having those concepts is really important to maintaining a diverse student body. And as you'll see, spoiler alert, that's also going to be really important to maintaining a diverse workforce when we're talking in the employer context. It also talked about providing prospective students with messaging that reinforces a commitment that all students are welcome. Where might else we see stuff like that? In our DE&I initiatives, talking about what are we putting out in the world to help reinforce that this is a welcome, inclusive work environment. They also talked about having targeted outreach, recruitment, and pathway program strategies, how we are approaching these things. Now, I will say, when we're thinking about this process, one thing that I do want to just make sure that we're all thinking about kind of in our lexicon is sometimes there is an equivalency that's made that just because we are talking about an underrepresented demographic, that automatically means that they are somehow disadvantaged or always in kind of a negative light. Now, there are statistical correlations, and we can talk about things that are most likely to be the case, but I do want you to be thoughtful about, as you go through this process, to not necessarily always equate a particular demographic with a standard or a socioeconomic status or a standard of, well, this geographic area that might be, less desirable or something of that nature. So just put that little kind of tidbit in your head. But when we talk about drawing those correlations, those statistical correlations, exactly like Colin said, that the colleges were doing and making those socioeconomic correlations, that's appropriate there, but just as a note there. They also want to make sure that we're reviewing policies and procedures to ensure that they highlight and prioritize the attributes that the college and university values most. And one of the things when we start talking a little bit more as we dig into this, it is going to be critically important for companies to identify what are their core values, what are the attributes and things that they value the most, and that's going to help guide some of these decisions that you make. Of course, you're going to have a lens for risk. Of course, you're going to have a lens for making sure that we are doing things lawfully. But you do want to make sure that as we're going through this process, that we're being thoughtful about that.
Hey,
Now,
Sheila. Oh,
yeah.
I'm sorry. Just a quick timing thing, just to let you know we're at the 20-minute mark, just that way.
Thank you. I appreciate that. So one thing, and we've kind of let this know, that the decision does not impact employment laws for now. It is already unlawful to use race or any particular protected characteristic to make an employment decision. So we're clear there, right? And schools were able to use race in their admissions process, but not here. The other thing that I want to know, especially for my federal contractors out there, this decision does not impact your affirmative action obligations. If you are a federal contractor, despite the name that's there, does not impact that. But where we are seeing this impact in the employment space is in DEI programs. They're not specifically addressed in the decision, but as we'll talk about, they are currently under fire as we go through and see the continuing ripple effects of this decision.
So when we dig into those sort of consequences, and we'll pick up a little bit of steam, because I know that, you know, the bulk of this, we definitely want to touch on, you know, how we address this, but it is really important for Sheila and me that we provide the broadest sense of the landscape right now, because the landscape right now is going to dictate what folks have to do going forward. Outside of that SCOTUS decision, we've obviously seen a pretty highly publicized bill out of Florida. We've seen bills that are in the works in Texas, Tennessee, North Dakota, each of which touch on DEI in either the university setting or in the public employment setting, but that carry the tone and tenor of that SCOTUS decision through into legislation. At this time, there are not bills that we're aware of or that are tracking closely or close to being passed that would necessarily touch on private employment, but that's part of the background. Is we have several states who are taking a really strong stance on this and using this case and this moment to message that really directly. Sheila will also talk, I think, a little bit about, you know, if you talk about state action, we have senators and we have attorneys general who are taking action as well, each of which touches on that close sort of a tie between the employment space and that education space and how that might be impacted.
Absolutely. And just very briefly for context, we've got Senator Tom Cotton sending a letter to really big law firms, letting them know that if you're providing advice or you're talking about DE&I programs, that could be violating the law, already equating a decision about higher ed to Title VII. We've had several attorneys generals, I've listed them on the screen, who have sent letters to companies letting them know that they are going to be held accountable if they have DEI programs that are going to be violating the anti-discrimination laws and obligations there. There was a response there that was a pledge to support from different entities, but that really has escalated probably within the last 2 weeks to some actual lawsuits that we've seen. We'll go with the last month or so that Colin's going to touch on briefly.
Yeah, I mean, it's no surprise. We talked about Mr. Bloom. He's sort of carrying that trajectory from the education space, previously the voting space, into employment space and sort of into venture capital as well. The Fearless Fund, which is a venture capital firm that focuses on raising money and funding businesses for women of color, received a lawsuit from Mr. Bloom and sort of one of his aligned groups. And the focus in that lawsuit that I really do want to focus in on, because I think it's going to be really essential to understanding the advice we give going forward, is the Fearless Fund's objective, which is funding only women founders of color, is the specific issue that this lawsuit takes up, right? The idea that we have a singular purpose or a directed purpose, and that singular or directed purpose is towards minority groups, right? If we look at the employment cases that we've seen, and these are employment cases that have been filed against law firms for their summer programs, their diversity fellowships, and things along those lines, we've seen that exact same logic extended. It is not a function of having a DE&I policy, a program, a team, a focus and emphasis. It is a function of having a program in place with a singular objective to assist, to lift up, to raise, to increase inclusion of a particular group at the expense, and this is some pretty artful phrasing from an attorney, of what would be considered sort of the non-minority protected group. And I think these are really helpful to understand. And I think a key part of unpacking this is knowing we won't know how these cases play out. We won't know how these demand letters necessarily play out for years. If I'm wrong, Sheila, correct me, but I think the Harvard case started from something that occurred in 2017, right? I think the actual
Yeah, I believe so.
filing. Yeah, so that's 6 years. So these cases, to the extent they're going to upend the apple cart, it might take 2, 3, 4, 6 years for those cases to ultimately come out. The majority of these will either go away or settle or be dismissed, or who knows what might happen. But we're seeing the logic. And the logic that's being pushed, similar to the logic that was pushed in the education cases, was this idea of a singular focus, of something that is designed to help A to the exclusion of B. That's the logic that these advocates use. And it's the logic that we are applying when we talk through sort of what we think best guidance is on a go-forward basis. And Sheila, I will leave you to jump in and talk about that, because your DEI background far outstrips mine.
Thanks, Colin. So I won't belabor the point that we all know that there is a huge value to DEI in the workplace. Study upon study, year over year, has said that the importance of diverse teams cannot be understated, that we have a value, whether it's a business case, whether it's a morale case, whatever that is, that DEI is important to us. And we've had a lot of emphasis since George Floyd, really from a lot of companies, on having these DEI programs that are very, very robust. And the thing that I want to say, just kind of as the outset, is DEI programs are going to continue to play an important role in the workplace. And at no point are we saying you don't need to have them, you need to do away with them. That is not the case. You do want to make sure, though, that you're being thoughtful about their execution and what their impact is there. Because DE&I programs, if they're managed appropriately and they do what they're designed to do, they are really going to be a really huge support for your workforces. Those of you that have DE&I programs, you probably have seen the benefits coming out of those. But I do want to talk about just a few aspects of DEI programs that are typically some elements that you want to be thoughtful about as we approach this. We spent some time earlier talking about recruiting and how that is going to impact the pipeline for the individuals that are coming in your workforce. Oftentimes you will have a lot of DEI focus on those recruiting elements. And so when you think about recruiting, you want to be thinking about what's your pool of applicants. As Colin mentioned, if you're only recruiting from Indeed, that's likely not going to be sufficient for you to have a really robust, diverse talent pool. So thinking about ways that you can expand your recruiting efforts, whether that is in a socioeconomic sense, whether that's in a geographic sense. I feel like a lot of us, especially coming out of the pandemic, there have been a lot of changes as we look at recruiting, as we look at the ways we work, as we look at a lot of the things that we do that have expanded our thoughts on recruiting. And this is just another area to think about as we're going through that. And with hiring and promotion, thinking through, of course, nothing about the decision changed with our hiring or recruiting. As I mentioned before, we're not going to be making any decisions based on particular race characteristics. But one thing you do want to think about is, and I think that's probably going to be the next frontier as we're looking at these cases, is if you're thinking about your DEI programs and they have aspects of diverse slates in them. That is something that is a concept that has been going on for a while. You have lots of prestigious certification programs that are kind of designed around having those. And most of the purveyors of those certification systems have said that they stand behind this aspect of their programs, that they are legally sound, and that they are something that employers should continue with going forward. But as you're thinking through, if you have a diverse slate process, or you have a process where you're only, and when I say diverse slate, I mean you might have a process or system in place where you say, we are only going to let this go forward in the next step of an interview process, as long as we have some type of diversity built into that slate process, whether it's for the interview, whether it's for the phone screen or the manager review, or what aspect that's there. That is still going to, I will say that's going to be a little bit of a gray area as we continue to go through this. Because remember, I said we're not going to be making any hiring decisions based on someone's status as a protected characteristic. But that aspect of a diverse slate, I think, is going to be something that is going to have a closer look from advocacy groups like this, because they might argue, well, if you've made the decision that this person goes on the slate because they are in a protected demographic, then that has been made to the exclusion of someone who is not in a protected demographic. You know, that would be something that we'd be fighting about in court, right? That's not something we don't think that that's the case, but just something to be mindful of, especially in the hiring and promotion category there. Another thing to be mindful about is if you have racial targets. Quotas are things that are completely illegal. But what we have seen, especially with a lot of DEI programs, is either an internal facing or an external facing target or goal that is put out for individuals, where we might have a racial target. When you have targets in place, that could be potentially misconstrued as setting a quota. So you want to be thoughtful about the word choice that you use, making sure that you're working with either your external or internal counsel about the language that's being used. And then you also want to evaluate how those targets that you might be setting, and we're not going to set targets, it's better to set goals, how those are actually being implemented in the workplace, and whether that is having the unintended effect of potentially having a decision being made based on someone's status in a particular demographic. So you want to be thoughtful about that. If you happen to operate in an international space, you also want to make sure that you are considering and being thoughtful about the international elements and different countries' views on diversity, equity, and inclusion, so that you have a very harmonized approach to that process that's there.
And one piece that Sheila touched on that I want to really emphasize is the internal communication around these goals, these targets in this area of emphasis. Time and again in litigation, we end up going through a massive e-discovery process. And that e-discovery process, particularly in these types of cases, is going to cast an incredibly broad net. And to the extent we have multiple stakeholders having conversations, those conversations not necessarily all happening in one venue, and one person says something that is inappropriate, that can be misconstrued in a certain way, it really can upend all of the strong intentionality behind this. So to the extent these conversations are happening internally, I think they need to be incredibly well structured. I think that we need to be relatively limited in terms of who we're soliciting input from, because the scope of discovery in these cases can really make a case difficult to defense, because it only takes, one person out of 20 to say something inappropriate or to carry, some form of messaging that we're not on board with, to undermine a much broader defense and a really well-meaning and impactful, solid policy.
Absolutely. And I see in the chat, someone had asked a question, is there any thought on any of these suggestions for LGBTQIA women, individuals with disabilities? And I will tell you, to the person that asked this question, this is something that we were actually talking about kind of in the pre-show aspect about this, is Title VII, which is the law that governs employment discrimination, is neutral in terms of the protected characteristics, right? No one protected status is more important than the other. And so when we're talking about race, which is of course the substance of the decision, if we're going to carry it over into the employment law space, We're then under Title VII, and we're then under this concept of all protected characteristics being protected, right? So even if we have like a racial target, that could easily say a gender target or an LGBTQIA target. Or if you're, having any particular target or approach to your DE&I programs that impact a protected characteristic. So that's a really, really excellent question. When we're, again, talking about Title VII, no one particular characteristic or protected characteristic, is weighed heavier than the other. So other things that we want to think about in our DEI programs is looking at our DEI training. This first kind of came on the scene when we're talking about DEI training. It started very early, actually towards the end of former President Trump's administration. One of the last executive orders that he did was about DEI training for federal contractors and how it needed to not have certain content, certain focus, some things that were saying like it shouldn't say things like, oh, one particular race is any better than the other. And just a side note deviation, if any of your DEI trainings are talking about one race or one protected characteristic being better than the other one, you need to get new DEI training. That's not good, right? We don't want any of that. So that was one of President Donald Trump's last executive orders that he did before leaving office. Very shortly into President Biden's term, he did an executive order kind of rolling that back. But where we see this coming up is the base of that executive order is pretty much the exact same language that you see in Florida's Stop Woke Act and their laws there too. And so there is a focus on DEI training. So it really is a good idea for you to, if you're doing training that is in person, making sure that you are auditing the content of what is being said, that you are evaluating the consultants that you might be utilizing with training. You might be, if you have DE&I folks within your companies, that we're aware of their sources of their content and where that information is coming from, because we don't want DEI training that's going to run afoul of this law. So again, free helpful hint, if it's going to be DE&I training that's going to talk about one race being better or stronger or different than another one, we probably need to be looking at that. But you do want to be looking at that. And do we need to adjust the focus there? Do we need to be talking about inclusive efforts there when we're talking about our DEI program? Mentoring programs is another really strong aspect of the DE&I space, right? If you're going to continue mentoring programs, one of the things that you want to be thoughtful about is providing opportunities for everyone. This gets really, really close to the concept that Colin was talking about. That's the basis of that, the venture capital case and the law firm case, right? If we have a particular benefit that is going to be for a particular race, then that gets closer and closer to the line of something that could potentially be challenged and that might have some risk associated with it. So you want to be thoughtful about looking at that. Having employee resource groups, those are a huge benefit to a lot of companies when we're talking about having affinity groups. It's a great opportunity for those that might have similar backgrounds to interact, to provide content for the employer. Really depends on how the company uses those. You do want to make sure, again, that there's equal access to those affinity groups or employee resource groups.
And one piece on mentoring really quickly, and the numbers here are huge. I think it's probably one of the most impactful things we can do. 80% of employees feel that mentoring improves inclusivity in the workplace. 90% of employees with mentors are happy at work. Those stats are affirmed time and time again. Now, mentoring with respect to many of the employees that are working in manufacturing might look and read a little bit differently. It's not like a law firm where I could walk down a partner's office and say, please tell me how to practice law. But there are ways that mentoring can be offered to employees who are working on the line in maybe a different way, where we are talking through opportunities for advancement, skill set development, where we're making sure that our supervisors are aware of how impactful their interactions with their line employees can be, and how that can build a sense of camaraderie and can develop a sense that allows the workplace to see that better retention, right? And then have the statistical backup to support it. And affinity groups play a huge role there, because if we're not in a position to offer that traditional mentoring, maybe we can create space for people to get together, to build relationships, to feel not necessarily that sense of family, but to feel a closeness to their coworkers that results in better performance and better retention.
Colin, you have
Oh.
struck a nerve with your comments about mentoring. There's like 2 or 3 questions in the chat about mentoring. One of them, can we have a mentor group that's just based on gender? Very similar one. Can we have a mentor group that's based on specific groups? And I will tell you, having mentoring groups that are based on a particular demographic, that gets closer to the line as we're talking about these cases. It's a little bit of a riskier proposition. That does not mean that it is illegal. I think when you're thinking about Title VII from a mentor standpoint, we're not making an employment decision in those contexts when we're talking about mentors. So I think that's a little bit kind of on the other spectrum. But when you're evaluating your DEI programs and thinking about where are some potential pressure points that we might have following this decision, if you have a grouping or an organization that is based on one particular demographic, you should really look at how that grouping is utilized, what type of resources they have, what type of decisions can they make, who is allowed to be in the groups, are they open to all? That really is going to be one of the things that's there. So
really great information, Sheila. I just want to let you know we're getting closer to the hour with the 5-minute mark. So just wanted to
thank you. This actually is the last slide. So perfect, Marissa.
Perfect.
Yes, perfect. So one of the other things that you have to think about, I think that's really important in this discussion piece, is not only your DEI programs internally, but all of the various stakeholders that you have when you're making this decision and when you're looking at this process. You are not only just looking at this from this risk standpoint, right? You've got a broader base of what do we stand for as a company? And every single day, companies make decisions based on various risk profiles and risk tolerance based on their culture, their values, and their ideals. So you also just want to be cognizant about making sure you're true to that North Star. What is the community in which you are operating in? What's going to be potential responses there, how you're going to address that from a PR and communication standpoint. You want to be thoughtful about what that content looks like in terms of risk profile, in terms of also what is going to be something that represents your company really well. A lot of times you might see DEI sources in human capital reports, sustainability reports. ESG reports are huge. In the S section, you really are going to be really talking about that. Sorry, not in the S section, but you're really going to be talking about in those reports what your DEI efforts really, really look like. And so you want to be thoughtful about how you phrase that language, and also, again, being true to what it is that you have in your workforce and what is important to you in terms of your goals there. And I do believe we have like 2 minutes, it looks like, for questions.
Which we fully appreciate might not be enough to dive into all this stuff. But the reason that we have our email addresses down there is, to the extent you'd like to reach out to either of us, we will answer that question. We are happy to provide whatever guidance we can, knowing that often Zoom is not the best venue for a lengthy thought or a lengthy response. To the extent we can help, we're here, we're ready and willing.
Absolutely. We'll end on this question. There was a question, there's a lot of focus on diversity and inclusion, but DEI also has an E in it. Where is the E in all of this? Where's the equity piece, the E piece, the equity piece that's there? One of the things from an equity standpoint is we're reviewing in our workforces to see that we have equitable access. And I think if you pull back some and look at a lot of your DE&I efforts through an equity lens, that's going to provide a little bit of clarity for you and probably some guidance there, right? So if we are looking at a mentorship program, and we could probably go back and forth about this, what does that look like from an equity standpoint? Are we providing equitable access to mentors for every person, for every employer? What does that look like? So the E piece is still alive and well in that discussion piece there.
No, that's really well put, Sheila. And I think we might just leave it there and be right on
So
the
I'm
nose.
just going to spend a minute to thank you, Colin, and thank you, Sheila and Linda, for organizing this and joining us to have this conversation today. There's so much to cover. And, you know, one thing that we said earlier, and I know it was one of the early slides, and just to underscore, this is going to be an evolving area of law and an evolving topic. So this is current as of today, and I know that we will all stay tuned for much more as this continues to evolve. But with Colin's point and the work the Institute's been doing for a long time, we have 2.1 million jobs that will go unfilled by the end of the decade. So we need an all of the above workforce solution, which means reaching out to as many people as we can and make sure that we're able to bring them in. So thank you all for joining us. Let us know what more questions you have, and we look forward to staying tuned for this conversation. So thanks very much. Have a good rest of the day.
Thank you, guys.
Thanks, everyone.